three preliminary trial matters.
Tagging on the first motion, Alex Johnson for the defense. We'd like to address defendant's motion to remove newspapers from the courthouse during the
All right, thank you.
As to argument for this motion, defense did have pre-marked this morning. I would move into evidence as one, what's been pre-marked today. A copy of the Osceola News Gazette that was present in the lobby this morning, which directly addresses the Stephan trial to begin July 22nd. The front page of the newspaper.
Has no position here.
Thanks. You received it. That's one for purposes.
So, as to this motion, with the recent denial of the motion to continue, the trial is set to begin next week in this courtroom. And as jurors, potential jurors and jurors that are selected in the trial walk into the courthouse, right in front of security or right beyond security, is a slew of newspapers, including newspapers like the Osceola News Gazette, which every time we've had court appearance, Stephan Stearns has appeared on the front page of the newspaper, and the newspapers constantly indicate that there's both a sex case that is currently pending, which is what we're here for this morning, as well as a capital murder. So, defense is requesting that just during the pendency of the trial, not ongoing in order going forward, that we remove these papers so that way the jurors, as they come in, go about the courthouse.
State takes a position. I have confirmed with jury services that jury services do not provide newspapers to potential jurors. Court always has to be careful balancing the right to free press and the right to open and fair jury trials. I do find that should there be newspapers available where the jurors. Can you give me some guidance as to where this table is downstairs? Is it over by the employee area? Is it where the general public would come in?
It's where the general public comes in. It's so if you're looking at the first floor, there's the area where you go to the elevators, and then there's the mirror there.
Yes.
It's the table's right in front of that.
Progress screens.
Yeah, exactly.
I have inquired as to our court administration provides the newspapers. I think that's a county function. We have proactively reached out to the county to see if we can suspend delivery of newspapers during the selection process throughout the trial. So the motion is preliminarily granted. We will direct parties that provide the newspapers not to do so during the jury selection trial process.
Defenses would next like to proceed on the defense's motion to order all media to adhere to the rules of judicial administration and administrative order. Essentially, Judge, defense is asking, according to, as the rules require, that the media, and since defense is on the left side of this courtroom and the media is positioned directly behind us, their cameras intentionally, inadvertently, I'm not saying that they're doing it intentionally, is focused on counsel's table in order to get views of Mr. Stephan of that nature. So in position, counsel's computer screens are in view of the media, so defense is requesting that the media not be allowed to look at, zoom in on, or otherwise project essentially onto counsel's table because of work product and attorney-client confidentiality. I understand that attorney-client confidentiality, we have to essentially affirmatively attempt to protect it. And when you have communications, we do mute the mic. However, because the table is so large and facing, it's just asking the media not be in order, not be allowed to zoom in on our computers or our computer screen. Under the administrative order, it says that communications between attorneys and their clients, between counsel and co-counsel, or anything that's held at the event is required not to be recorded or broadcasted. So it becomes a position that anything that's occurring essentially at the council table in terms of notes, whether that be handwritten notes or computer screen notes, not be looked at. The DIS has taken affirmative steps to have a privacy screen and additionally dimming the lighting on the laptops. However, even with that, it still is doable for the media, and sitting in court with dim screens and dark lights for multiple hours is going to cost headaches, but also to protect not only Mr. Stern's confidentiality, but potential other clients' information who we're working on while we're in court. The media not to allow. So look at zooming in on computers or counsel's computers.
Remember, the state doesn't have a position. However, I think if the court is going to issue an order, it needs to be everybody in the courtroom, not just specifically media.
Are you saying to the state as well, media personnel, or anyone not being able to do it?
There's a lot of amateur media people that will cover this trial, and they use phones, from my experience in other high-profile trials. So the order should be broad enough that it covers everybody in the courtroom, perhaps even an order that people in the gallery should not be allowed to have their phones out during the trial. Yeah. Sometimes they need daily reminders, sometimes they need multiple daily reminders, but they also focus on the state's computer, and we are obviously against that for the same reasons.
And there's no objection to the law.
All right, our relationship with the media has been a good one. They are an essential community partner. And as I said, the court's going to strive to ensure that this is both an open trial and a fair trial. The days of passing notes back and forth are behind us. A real experience working with each of the attorneys. Here I know that your coordination with witnesses, with each other, with presentation, with evidence is highly computerized. The court will expect that the media will comply with Florida Rule of Judicial Administration 2.450 as well as our Administrative Order 2023-23. That order is fairly specific under subsection 2E. Indicates that representatives do not cover sidebar bench conferences, no recordings of conferences or information that occurs between attorneys and the clients, co-counsel, between counsel and the presiding judge, public bench. I've done several trials where the media was involved. The only violations of 2.450 in our administrative order, in my opinion, have been inadvertent. Issues were the camera operator perhaps went to a wide shot that included faces of the jurors during the trial, or there was a microphone that was inadvertently picking up communications through the microphones at the council table after the microphones had been apparently muted by the attorneys. These are technical issues. We have a technical team here that the media is absolutely welcome to coordinate with. The administrative rule gives the media an opportunity to meet with our court administration if they have any questions about what the court's expectations will be. The court will expect that media representatives will be credentialed pursuant to the rule. Non-credentialed members will not be permitted to have out cell phones as members of the general public. So I see no issue with the defense's request to have the media comply with the rules that are already in place. The motion is granted. If representatives of the media have specific questions, they may contact my office. I will direct them to our court administration personnel, provide a copy of the administrative rule, which I'm sure they are most familiar with, and judicial rule, Florida Rule of Judicial Administration. So the court will expect that will be scrupulously followed in an effort not to impede fairness. State participants presenting any witnesses in support of restraints.
The state just has one. Richard Rizzo.
Thank you.
He solemnly swear or affirm
Yep.
Good morning. Will you spell your first and last name for the record?
Yes, Ricardo, Ricardo. Last name is Rosario, Rosario.
How long have you been employed as a court deputy?
Since March of 2017.
And is your primary assignment to this courtroom that we're actually in right now?
Yes.
Are there policies in place for the use of any type of restraints during a felony criminal trial for an accused?
That's correct.
And how many felony criminal trials have you participated in as a court deputy?
You want to count this? I can't remember how many.
That's fair. What type of devices or restraints are available that would be out of the view of members of the jury?
So each courtroom has one device is kept downstairs in the first floor, which is a stun cuff. And in the courtrooms, we have a leg brace.
How is a leg brace utilized by court deputies during the pendency of a criminal trial?
So a leg brace is essentially a long bar. It has 4 straps. And in the center, there's a tab that you can pull so the person can sit down. Otherwise, the bar won't bend. So basically what happens is when the person sits, it bends, but when they stand up, it just locks. It prevents the person to run away. It would have to essentially hop away because that leg is stiff.
Are there any safety concerns for you as a court deputy in this courtroom should a accused during the criminal trial not be equipped with such a thing as a leg brace?
That's correct. So when any inmate is brought over to the courthouse, they're restrained, handcuffs, and leg chains. When they're brought over for a trial, they are dressed out in proper attire, suit, and at that point, they're in the custody of the sheriff's office, and we have to maintain a level of safety and security for the inmate and as well for everybody else in the courtroom. So that's the reason why we utilize those restraints.
Is there limited staff here at the courthouse for the sheriff's office?
The felony courtrooms will have 3 deputies. Misdemeanor courtroom would have 2, and civil would have 1. But due to staffing, sometimes people take off or they're sick, and it creates a safety hazard if you're running a high-profile felony case with just 2 deputies. So hence the reason why we use also the device.
Is this device something that is visible to anybody that is looking at the outer appearance of an inmate that's wearing it?
No.
Is this device something that delivers a shock or pulse of electricity or anything like that?
That's correct.
It does or it does not?
It does. So essentially, this is a stun cuff that's wrapped around a inmate's ankle and is tucked away under the clothing. There are 2 metal pieces here that is close to the subject's skin, and the strap is placed accordingly and wrapped not tightly but snug that it won't fall off. The remote is this right here, which is kept at all times with a deputy within the courtroom. Nobody knows who has it. It's hidden discreetly. No one sees it. to activate this, it's a two-step process. There's on, and then there's fire. So the device won't accidentally fire on itself. It has to have a two-step button to fire the device.
And the device isn't triggered by movements of an individual or anything like that either.
That's correct.
And is this something that is utilized by court staff in addition to the leg brace that you described?
It's one or the other.
So there's two options that are potentially available to court deputies depending on the scenario.
Correct.
And both of these options are outside the view of anybody that is looking at the outer appearance of an individual as long as they're wearing their pants.
Correct. So when we put these devices on, inmate that's scheduled for trial, it's out of the view of the public, it's out of the view of the jurors. No one knows that the person set for trial has it on.
Let's talk a little bit about writing utensils. If there is an inmate present in court, are they given a writing utensil?
Yes, they do. The pen is designed to fold and flex, as opposed to another pen or a big pen or a metal pen that can actually be used as a more deadly device.
It's a safety concern for court deputies.
Yes.
For the purposes of this trial next week, what is the type of restraint that court staff deemed is appropriate for this?
We will be utilizing the stun cuff, and actually this is a newer version. The older version is a much bigger, broader box. This one is a newer one. So we'll be using this one right here.
Now, you talked about two different devices, and you indicated that the stun cuff is the intention in this case, correct?
Yes, ma'am.
And is that because that's generally what's used in this courtroom, or because of what?
99.99% of the time, we always use a stun cuff.
So I want to talk a little bit about the leg brace, since you did talk about that. Now, this leg brace, this is a longer device. Like it's not as small as the stun cuff, correct?
Right. It's essentially a metal bar. It's pretty long and it has 4 straps.
And to your knowledge, is that comfortable or uncomfortable?
I would say rather a bit more cumbersome because it's strapped alongside the leg of the person, and if they stretch their leg, it'll snap shut.
So essentially, normal movements could cause it to lock up.
Yeah, as soon as the person stands up, it will lock.
And then the stun cuff, I know you talked about this being a smaller apparatus that goes typically closer to the ankle, correct?
Correct.
And depending on the type of pants or clothing that is worn by the person, that could affect the visibility of the item.
Yes. So normally, male inmates will always have long pants, and the cuffs go right around it, so you really can't see it.
But the pants legs will have to be wide enough to kind of flow and fall over so it wouldn't be visible, correct?
Yes, and we always apply to the right leg, which is furthest away from the jurors.
And typically when sitting down, your pants often rise, generally speaking, correct?
Yes.
And so if the pants are shorter, then the stun cuff at that point would be visible, likely?
Possibly.
And those straps, I know we saw kind of like the strap that goes around. Where does the extra, so to speak, of that tuck in, or does it tuck in somewhere?
So when you apply this apparatus, it wraps around, and then the strap goes through here, so it holds it down.
So similar to a belt, you know how when you use a belt and you have the extra, where would you tuck in, or where does that extra strap go?
It just remains there, and it just folds in.
So would it be secured, or would it be kind of sticking out?
Just stick it out very, I mean, you would really have to look for it to find it.
Okay. Now you talked about the two-step process with that remote for the stun cuff. I believe you said it was an on and a fire, correct? So does that mean that once the stun cuff is applied, it's typically automatically in that on position, and then you just have to go to step 2 or something else?
Well, the apparatus is turned on, so it's always going to be on, but to fire it, you have to press the on button again and then press fire.
Okay. And those 2 buttons are, I don't want to assume. Are they next to each other on the remote? Or are they two different areas of the remote?
Yeah, so the on, then we would have to switch over to fire.
So one side is on and one side is fire.
Right.
And I believe you said that typically one deputy has it, maybe between the three of you or two of you, depending on how many are in here. You guys would know, but none of the other court
Nobody
personnel.
knows who has it.
Just the person who has it, I assume.
Yes.
So you would know that you don't have it, and so if there's only two of you, by process of elimination, the other person would have it.
Correct. So essentially, when we do a courtroom operation, each deputy has an assignment. One is for the inmate, one is for the jurors, and one is for the security of everybody.
Now let's talk about the writing utensil. You talked about this flex pen or the flexi pen, about how it's designed to collapse in on itself. Now this pen still does have a normal point, like that a ballpoint pen would have, correct?
Right.
Would the utilization of, say, a felt pen be something that would potentially not be a safety measure?
Well, we're not really concerned about the tip of the pen. We're concerned more with the body of the pen. A more firm structure to be used as a stabbing type weapon.
And with, are you familiar with felt pens? Okay. Now with those, typically that point, it's soft, correct?
Yes.
And with the flexi pens, and even with the stun cuff, those are only utilized for people who are in custody, correct? If an inmate who wasn't in custody was sitting at counsel table, he wouldn't have to have on, or she would not have to have on a stun cuff or a leg brace, correct?
Right.
And writing utensil, if a person was out of custody, they also would not have to use a flexi pen, correct?
We normally give them flex.
Even a person who's out of custody?
Yes.
In terms of, I know you talked a lot about safety. Are you aware of any attempted escapes or anything like that for Mr. Stearns?
Of Mr. Stearns or any other inmate?
This is not specifically.
No.
Any defendants complain about the comfort of the stun cuff or the leg brace?
No. So essentially, if the stun cuff, we put it not too tight, so it doesn't impede with blood flow or anything, or potentially injury, but it is placed snug, so this way it won't slip out. So, but we've not had complaints.
So no one's ever complained about like itching or discomfort or rubbing?
No.
What about with the leg brace?
I've not had much use of the leg brace. So the leg brace, to be clear, is if the courthouse has a number of jury trials of that day, and these stun cuffs are placed in the chargers, respectively, downstairs in our office. And whoever gets there first just grabs them. Then we just have to go to the leg brace because there's no more stun cuffs.
Okay. And do you know how many stun cuffs the sheriff's office has in terms of within the courthouse?
Well, I believe we have 4.
Defense in this case is asking that Mr. Stearns be free of the rule as either use of the leg brace or the stun cuff. And we're also asking for the use of a regular writing utensil in this case.
Why? Why do you care what writing utensil is?
Judge, in prior experience, the flexi pens, they often skip, they often don't have ink, or they don't write well. So when it's hired to communicate, especially in something not use the microphone, so they can't compare the questions that are being asked, having a utensil that writes and functions easily and freely as opposed to having to stop, well, not necessarily stop the proceedings, but trying to get a deputy's attention to get us another flex pen while we're also trying to watch what is being presented, listen for objections, or making necessary objections. Essentially, it's a distraction if we're having to make sure that his pen is working, he's able to communicate with us, or being able to read it if it's skipping, so we're trying to figure out essentially what are the holes in the bubbles of what he's writing. Generally speaking, the flexi pens in the past haven't been the best. And I understand, kind of like a regular pen, you grab one out of the box, if it works good, it works good. So we're asking for like a felt tip, and I understand the deputy's testimony in terms of the safety concern. It's the defense's position that the use of a felt tip pen, being it's a soft tip, it's essentially a marker, we would give it to him without the cap, would be sufficient. He would be able to write and communicate with us easily and effortlessly without having to worry about him stopping or not working and things of that nature. So we're asking for the use of a regular writing utensil as opposed to a felt tip pen utilized. And then in terms of the restraints, again, we're asking for Mr. Stearns to be free of physical restraint. I understand the policy of the sheriff's office and things of that nature. However, it's for you to case by case basis, not a general policy that applies across the board. There's been no testimony of the escape attempts and instances of violence during the course of incarceration. However, the deputy actually testified to the opposite. That he's compliant, that he listens, follows directions, does what he gets asked. So, and I understand the staffing issue. However, at this point, they're not aware of the number of deputies that will or won't be in court anyways. So the defense is asking that Mr. Stearns be free of physical restraints. Because if he was out of custody in this case, he would not have physical restraints. I know the deputy testified that typically people who are out of custody also use flex pens. That hasn't generally been my experience in this courtroom, but that could have changed since the last time I've done a trial here in this courtroom. The defense is asking that Mr. Stearns be free of physical restraints.
Yes, Your Honor, the state provided testimony through Deputy Rosario, who testified as to what type of restraint would be used for this trial should the court deny the motion. The process of utilizing that stun cuff. Also, he testified as to any potential safety concerns with this being a felony criminal trial, and also any safety concerns with the type of writing provided. The state would request that the court deny the defense's motion.
I see one of the safety ones. Do we have one? All right, for purposes of the record, the safety pins, they basically internal tube that has the ink in it, surrounded by a clear rubber tube. Also about 3 inches long, but essentially different than the writing instruments that the attorneys would use. On the shackle motion, we're not uncharted territory. There's case law that applies to this case. We would state 894 second 178. Supreme Court case from 2004. In that case, there was a defendant that was charged with serious crime. In the appeal, he took issue with the electronic restraining device dealt in that case. In that case, cited the United States v. Durham, 287, Federal 3rd, 1297, 11th Circuit, 2002 case. In that case, the 11th Circuit indicated that a Sunbelt poses a greater threat to the dignity of the courtroom than shackles that were based on a potential that it is reasonable to assume that much of the defendant's focus and attention when wearing a stud belt is occupied by anxiety over a possible trigger of the belt. Interestingly, in that case, there was an accidental discharge of the stun belt that occurred outside of the presence of the jury. The Supreme Court in that case found that the judge's discretion in exercising of the discretion to wear a stun belt was warranted. However, in that case, the defendant was pro se and was permitted freedom of movement about the courtroom. The Weaver case surmised that there was no lesser alternative other than the stun belt to allow freedom of movement, as well as accomplishing the concerns, which was a concern regarding escape or proximity to court. In this case, we do have an alternative. The court has never had an accidental discharge of the stun cuff. The court has not before had any indications that the stun cuff was visible to the jury. The court before has never been presented with argument that the defendant was preoccupied by the wearing of the sunblock, but in this case, Mr. Stearns will not have freedom of movement in the courtroom. Use of the leg brace, as well, has never received a complaint about the comfort of a leg brace. Because Mr. Stearns will not have freedom of movement, with certain prejudice to the fair trial proceeding to have Mr. Stearns wear a leg brace that would, in the unlikely event that not be compliant, stand up and make an effort to exit the courtroom, that would lock and give resources that are on hand an opportunity to intervene. It understands that the matter should be considered on a case-by-case basis. The court can see no prejudice. The device will not be visible. The court has not before received a complaint about the comfort of that particular device. In fact, that Mr. Stearns will not be permitted to move about the courtroom anyway. The court can find that would be prejudicial, and the court finds that a consideration of the layout of this courtroom, proximity to the jury, proximity to the exit of the courtroom, severity of the allegations, the emotional nature of the jury to be presented, that a leg brace is warranted in order to implement it while he is present in the courtroom. Also have a private area that can be outfitted. I'll address continuing concerns with use the pen. He'll be provided with a felt pen. I'm going to ask that be specific to Mr. Stearns. That will remain in the courtroom. If the state makes a determination that closure of the court was warranted pursuant to statute and that's victim rights, Marcy as well, I'll ask that's your intention. You present that in writing and we'll address that. Give the defense an opportunity to weigh in on that.
Yes.
Okay. That's.
I believe those are all the
But as I said, the court will make itself available for the rest of this week and on Monday for access to the courtroom. If you have specialized concerns, equipment concerns, please be proactive in asking in advance and resolving those issues with court staff prior to jury selection.
So the first motion.
I'll conclude on here. Thank you. Are you going to provide the defense?
Yes, Judge, we can provide those.
We'll run those, screen in and let the judges take a look.
This is what our